Welcome to The Explainer. I'm absolutely thrilled you're joining us today because we are diving into a truly fascinating real-world administrative hearing out of Arizona. It's one of those cases that starts with something literally as simple as backyard landscaping, but then, boom, it quickly spirals into this rigorous legal battle over jurisdiction, the true limits of homeowner associations, and ultimately the fundamental right to control your own private property. Let's just get right into it. So let me ask you this right off the bat. Can your neighbor's backyard plans actually break the law? Now, I know it sounds like a petty suburban squabble, right? But for the residents of the Agua Dulce Homeowners Association down in Tucson, Arizona, this exact question became the absolute center of a formal legal petition. We aren't just talking about a squabble over an ugly fence here. This was a formal action brought right before the state's Department of Fire, Building, and Life Safety. Let's see exactly how this whole thing escalated into a genuine legal standoff. Which brings us to Section 1. The homeowner's complaint, and William Cavanaugh's battle against pollen. Okay, so let's unpack this. The petitioner in this specific case is a man named William Cavanaugh. He's a homeowner in the Agua Dulce community, and get this, he actually served on the community's very own architectural review committee. But he had a massive grievance with how things were being run. So, Cavanaugh files this petition, alleging the HOA is basically letting residents plant whatever non-native vegetation they want in their yards. Specifically, he was really upset about high pollen and high water usage plants. He's arguing, hey, the HOA is completely failing to follow the official approved plant list from Pima County. And for Cavanaugh, this was definitely not just some aesthetic issue. He actually testified that he was suffering from personal health issues as a direct result of all this vegetation planted around his neighborhood. Plus, he claimed that by allowing these specific plants, the HOA wasn't just breaking local rules. They were in direct violation of both Pima County Zoning Laws and the HOA's very own governing documents, their CC&Rs. All right, moving on to Section 2, the HOA's defense, exploring property rights versus neighborhood compliance. Now, there is just a completely stark contrast in how these two sides are viewing the battlefield here. On one hand, you've got Cavanaugh. His arguments are super localized and highly personal. He's focused on his health issues, strict adherence to local Pima County zoning rules, and the environmental impact of these high-water, high-pollen plants. But then you look at the HOA's defense. The HOA basically takes a huge step back and looks at these structural rules of the game. They aren't even really debating the biology of the plants at all. Instead, they're arguing a lack of subject matter jurisdiction. They're essentially saying that enforcing Cavanaugh's demands would totally trample on private property rights, and they made sure to point out the incredibly high costs of ripping out existing landscaping. It is your classic, textbook clash between strict municipal compliance and the actual practical realities of managing a private residential community. To really put a human face on the HOA's defense, just consider this specific testimony from Terry Anderson. He's another homeowner in Agua Dulce, and he testified at the hearing that he was, quote, concerned about the possibility of private property rights being trampled. And you know what? He definitely was not alone in feeling that way. Anderson noted his deep, deep concern about the potential financial devastation here. I mean, think about the sheer cost of forcing homeowners to rip out mature vegetation that's already planted, already thriving in their own private backyards, all because of one single neighbor's petition. And the HOA didn't just sit back and rely on homeowner opinions either. They brought the receipts. They had two key figures testify, Linda Ware, who's a member of the Architectural Review Committee, and Betty Blaylock, the president of the HOA board. This right here brilliantly illustrates how proactive the HOA actually was. Ms. Ware testified that she literally went straight to Pima County officials herself just to get some clarity on these zoning laws. And the county's response? They informed her that they simply were not concerned about the vegetation planted in homeowners' private backyards, period. The HOA kept strict guidelines for the front yards to make sure the neighborhood looked uniform, sure, but they considered those backyards to be the totally private domain of the homeowner, and crucially, the county completely agreed with them. So that sets up Section 3, the legal battleground, and the rules of the game. Okay, let's take a look at the legal framework that Administrative Law Judge M. Douglas had to use to actually decide this dispute. Now, in an administrative hearing like this one, the burden of proof falls entirely squarely on the person bringing the claim. So, Mr. Cavanaugh, he had to prove his allegations by a preponderance of the evidence. According to Morris K. Udall's Arizona Law of Evidence, which was cited here, that means such proof as convinces the trier of fact that the contention is more probably true than not. Simply put, Cavanaugh had to prove that it was more than 50% likely that his claims against the HOA were factually and legally valid. It's not like a criminal trial where it's beyond a reasonable doubt, but you still definitely need solid, credible proof to win. But here's the catch. Before a judge can even start weighing any of that evidence, they have to clear this massive procedural hurdle first: subject matter jurisdiction. You can kind of think of this as the ultimate trump card in the legal world. It's the fundamental authority of a specific court or department to even be allowed to hear a particular type of case in the first place. Remember, Cavanaugh brought his petition to a state entity, the Department of Fire, Building, and Life Safety. Well, the HOA essentially argued, hey, a state department has absolutely zero authority to interpret or enforce a local Pima County zoning ordinance. And they're right. If the department lacks subject matter jurisdiction, then literally all of Cavanaugh's evidence about the pollen and the non-native plants, it's entirely legally irrelevant. And that brings us perfectly to Section 4, the final verdict. We're looking at the judge's ruling and procedural finality. So here is the absolutely crucial point of the whole case. The petition was dismissed. On March 11, 2013, Administrative Law Judge M. Douglas issued the decision, basically finding two fatal flaws in Cavanaugh's case. First up, the judge stated that Cavanaugh completely failed to present any credible evidence that the Agua Dulce HOA had actually violated any state statutes regarding homeowners associations, or that they'd even violated their own CC&Rs. And second, totally validating the HOA's primary defense, the judge concluded that the State Department simply does not have jurisdiction over alleged violations of Pima County zoning codes. Think about it. Cavanaugh took a local county zoning complaint and handed it to a state agency that monitors planned communities. It was just the entirely wrong legal venue from the very start. And honestly, this next part brilliantly illustrates the fascinating and sometimes surprisingly quiet mechanics of administrative law. Because when the administrative law judge makes a decision, it's technically just a recommended order. It doesn't instantly become final law. Just walk through this timeline with me for a second. Step 1. On March 12, the judge's decision was electronically transmitted over to the director of the department. Step 2. By law, the department now had a ticking clock. They had until April 16 to formally accept, reject, or modify that judge's decision. And then, Step 3, April 16 came and went, and the department took absolutely no action. They remained totally silent. Well, in administrative law, inaction is an action. By doing absolutely nothing, the department allowed the decision to stand. So, right on April 17, the director of the Office of Administrative Hearings officially certified the judge's dismissal as the final administrative decision. The whole shebang was officially over. Which finally brings us back around to this really provocative question: where exactly does your HOA's power end and local government begin? This case is such a perfect reminder that while we might really want strict rules to protect our health, our neighborhood aesthetics, or our property values, the actual legal mechanisms to enforce those rules are highly specific. You just cannot use a state agency to enforce a county law against your neighbor's private backyard. Thank you so much for joining me for this explainer. I really hope this structured look at the evidence has given you a clearer and honestly more fascinating view of the incredibly complex legal ecosystem that exists right in our very own neighborhoods.